things I think that the Cyber Initiatives Group does consistently is hosts conversations among experts. It's not just people who don't always have the level of expertise on a subject matter interviewing someone else, but these conversations between experts themselves. So it is my great pleasure to announce the next session. We're really focusing on kind of a duty to report what SEC and public notification requirements mean for business. It's been a very controversial, very sensitive subject, but one that has to be dealt with. I'm going to turn the floor over to help businesses figure out how to navigate all this to Leslie Ireland, who's going to be moderating this. She is one of our SIG principals. She's also a board member at Citigroup and the former Assistant Secretary for Intelligence and Analysis at the U.S. Department of Treasury. And she'll be talking with John Carlin, another one of our favorites and part of the Cyber Initiatives Group as well. He's a partner now at Paul Weiss, but he was most recently the former Principal Associate Deputy Attorney General at the Department of Justice. So I've got my notes ready here for both of you. Over to you, and thank you both for being here.
Great, thank you, Suzanne, and it's a pleasure to be here today with you, John. It's always a pleasure to be with you, and I know you've got a lot of insight on this subject as we start to dig into it. So I thought we could kick it off. If you could give us a sense of where you see the threat landscape that companies and organizations need to be worried about right now.
Thanks, Leslie, and it's great to be back with the Cipher Brief and following that fascinating panel before us, which hits, I think, on some of the key threats that we're facing here. But you know, the four main nation-state actors have remained the same, and that's been fairly constant. So that's China, Russia, North Korea, and Iran. I'll just say we've seen a little bit of a dip or decrease in activity that can be attributed to Iran or to criminal groups that are affiliated with Iran and may have links to the nation-state government. North Korea continues to be essentially the world's largest bank robber and is actively using criminal cyber techniques in order to get currency into the system that they're otherwise deprived of because of the effectiveness of not just US, but other sanctions as well. And you're also seeing this interesting, both by direct theft of digital currency and by demanding extortion payments through digital currency, you're seeing a fair amount. And when I say seeing, I mean seeing because of the transparency of the blockchain that's used for the movement of digital currency, funds that the North Koreans have stolen, but they're having trouble translating it, getting it out from digital currency into fiat currency to use it. And that game of cat and mouse by both governments and also with the provider continues and is one to watch. Russia, I think, continues. Russian organized criminal groups seem to have recovered, at least in part, from a surprising dip after the Russian aggression into Ukraine. I think we expected to see both increased Russian nation-state activity against private sector actors, along with organized criminal group activity that often acts on behalf and certainly acts with the knowing turning of the eyes and from their activity in Russia where they have safe harbor. And I think a little bit on that, Leslie, it was a surprising output of shouldn't have been surprising, I guess, but people hadn't focused on it, which is a lot of the most successful organized criminal groups that were conducting things like ransomware for profit, attacking private companies, stealing information and demanding extortion through digital currency, or locking up their networks and demanding payment in order to get the key to have your network available again. A lot of those groups were crossed the Russia-Ukraine divide, and so shared a common language. And post-aggression, some of the groups, there's nothing like bombing where you live to change your opinion of another country. And so those groups split a little bit along Russia-Ukrainian lines. They started attacking each other. They started doing attacks on each other's nation states on behalf of the nation, but also on their own. That created opportunities for disruption. And there was, I believe, most experts agree, a slight dip in 2022. I think in 2023, that's activity has increased again. And then China, we just heard about, but you continue to see both sophisticated nation state campaigns targeting, as they traditionally have, intellectual property, but also trying to stay hidden so they are inside critical systems they deem critical in the event of a conflict, could exploit that access to cause disruption. And more generally, criminal groups, this is just located throughout the world, not linked to any nation state. I think that trend line is going up again. So the unfortunate news is, extent 2021 was the worst year. 2022 was a bit of a dip. We seem to be back on trend of it. They continue to invest more in becoming better criminals, and the threat environment continues to get worse.
Better criminals. I think that's a phrase I'm going to take away from this. So it sounds like, understandably, the threat is ever present and increasing, and the efforts for different regulators, entities to try and get an insight into these attacks has also been changing. So the one that we're going to talk most about today is the recent SEC ruling. And I thought specifically on materiality and a requirement to report within 4 days of determining materiality of an incident. What I was hoping you could do is give us a sense of how we got here and exactly what is expected from this ruling that I believe takes effect in December. Is that right?
Yeah, it's likely December.
Okay.
They have the implementation date has a trigger of 90 days after the federal rule is published, December 18th or December 18th, whichever is later. So
Okay.
I think likely December 18th, and that's understandably, given Leslie, and we've talked about this a little bit from where you said, as someone who sits on boards, including on the board of a major financial institution like Citi, that timeline affects larger companies. For smaller companies, they have until June 15th, roughly, of 2024. So they have a little more time.
Thank you for clarifying that.
Thanks. Rules. Outside the time, though, just going up 30,000 feet on what the climate is. So threat environment is bad, poses national security risks, as we just discussed. And I think what you're seeing is kind of an interesting divide in the United States, but we're also seeing it globally, which is it's almost a schizophrenia. And so on the one hand, you have the law enforcement and intelligence agencies who recognize that the victims here are private companies, the infrastructure, over 90% of it, in private hands. We don't have mandatory reporting. There is a statute, new Cyber Incident Reporting Act, that will require, if you're in particular sectors, some mandatory reporting to the Department of Homeland Security, but not for at least another year. And in that environment, we need to help the victims, and we need to encourage victims to come forward and not feel as if, as we've had in other areas of criminal law, right, to not feel like you're being re-victimized through the process, or things are being made worse because you chose to come forward and report an incident. So at the FBI in particular, but also Secret Service, you're seeing with state and locals. I mean, you had a comment of the head of the cyber division from the FBI said, I want my folks to be the Ritz-Carlton of customer service when it comes to victims. You don't hear that very often from an FBI official. So they really have changed their approach, something I worked on when we were back at the Justice Department, where the ransomware task force set up to go after these bad guys wasn't just focused on criminally prosecuting, but also really working with victims on what can we do to help you. And so that's included innovative new techniques, like you get hacked in the instance of Colonial Pipeline, a group emanating out of Russia under the name Are Evil. So if you're wondering, are they good? Are they evil? They're evil. And they were ultimately sanctioned through the Treasury Department. But a group like that, you know, instead of just trying to go after them criminally or designating them for as an entity which is sanctioned, which means in the future that people can't make payments to them, even in the event of ransomware, which drove the group ultimately to disrupt. But in that case, the Justice Department didn't just do that. But working with others in the Intel community, they figured out where the wallet was that received the extortion payment from Colonial Pipeline, and the hack that disrupted our, caused gas lines up around the southeast, northeast. They went and stole legally that which had been taken criminally and gave it back to the victim. Or to give another case, Kaseya, they secretly, in two operations actually, they secretly went, hacked the bad guy, stole the key that would be used to unlock ransomware, and without telling the bad guy, secretly provided it to victims so they could restore their networks. So on the one hand, you have that whole victim-centric effort, we want to help you. And on the schizophrenia front, and this is where the SEC comes in, you have an almost unholy rush by the regulator with the exact opposite approach, not carrot, stick, to figure out what can we do to hold the victims responsible when they are victimized, when they are attacked. And the goal there, ultimately, or the legitimate policy goal would be to say, by increasing the costs, we want to change the cost-benefit analysis so people are putting more additional resources into both defending their systems or on resilience, making sure that it doesn't cause business interruption. The SEC is on the stick side of that equation, and I know from some clients that they're thinking of, if I were to name threat actors, it would be Russia, China, North Korea, Iran, criminal groups, and SEC, along with other regulators, because they feel under attack. So the new rule, though, is not as draconian as the one that was originally proposed back in March of 2022. So I do think they took some of the many comments about how the approach was wrong-headed and was going to re-victimize folks. And in the final rule that popped in late July, they modulated where they were going. And here's what it does cover, to your point. It covers two main areas. One, the reporting of material cyber incidents, and the second is around annual disclosures on cyber governance and risk management. At a high level, the material reporting requirements has a couple key things that everyone watching a public company should be aware of. So one is the scope of the disclosure, and I don't think this is that different really than the way I was seeing them already look at enforcement actions and advising clients, now they're not a government and working with victims, which is you need to disclose the nature, the scope, the timing of the incident, and then the material impact or reasonably likely material impact on the company, including financial conditions and operations. Not similar to other material incidents, from a hurricane to a product, an issue with a product being misdesigned. They created a new definition of cybersecurity incident as part of the rule. There, I think people are still concerned because it includes both an occurrence, and I think everyone knows already if it's a big, huge event and you're knocked out, I think Equifax or North Korea's attack on Sony, that could be a material event. But it also talks about a series of related unauthorized occurrences. And I think there's more concern about what does that mean, and could we have a bunch of small incidents, but someone's going to look back later with 2020 hindsight and say you should have put those all together and together said they were materiality. The definition of materiality is really consistent with the way it's applied throughout other areas of the SEC. A substantial likelihood that a reasonable investor would consider it important. And it includes, and this is another area I think people are wrestling with, quantitative, that's easier, what percentage of revenue impacted, et cetera, but also qualitative. And that one's a little harder on the reputation and how that might be interpreted for enforcement. I say harder, but in some ways I mean softer. It's a softer way of analysis, so it's easier to second guess unlike quantitative, where you could say, I did an analysis, and it's less than 1%, therefore it's not material. On the timing, and this is what you raised, they say without unreasonable delay to make the determination that it's material. And I think this is probably the most important thing. Maybe I'll pause, see if you have questions, comments on it. But it's not, when you have an incident, often at the beginning of an incident, it appears quite small, or you really just don't know what's occurring yet. And the rule isn't so unreasonable as to say, hey, I have to report out to all my shareholders and call this material when I really don't know what's happened. What it says is you really need to have a process internally that's defensible to show that you attempted to determine whether or not it was material in a reasonable, or to use the double negative they do, not unreasonable, period of time. Is this material? Once you conclude it is material, that's when the 4 days kicks in and you have to make the disclosure to investors. So I still think there's a lot of room there to make that determination in a reasonable time. Where I see people get jammed up is you're often in a crisis during that time. And you may have very good grounds for why you didn't conclude it was material, even if it gets worse a week or 2 weeks later, but no one memorialized, okay, here's the people, the key executives at the organization, here's how we notified the board, here's how we followed our normal disclosure committee requirements and made sure they were informed by the chief information security officer and the team that knows the most about the incidents. Here's what we knew at the time. Wasn't much, and based on what we knew at the time, didn't appear to be material. Everyone agreed. That documentation, that can be, that one page memorializing it can save you a lot of pain later in terms of an investigation and possible civil or criminal risk.
So it sounds like what you're talking about is perhaps for some companies, it might be, I shouldn't say business as usual, but they might have a governance structure that enables something like this to happen routinely. But for others, it's going to be looking at your governance differently and maybe looking at your tabletop exercises differently. Maybe materiality or lack of materiality and documenting that needs to become part of your routine exercising and preparing for cyber incidents.
Yeah, that's a great point. And just to emphasize the tabletop, for those who may not be familiar with a war game, this audience is often former government, and we're all used to tabletops for wargaming. I think it's newer still in the private sector, and in the cyberspace, people will often do a tabletop or a war game at the technical level. So here's how we'd respond if we see an unauthorized intruder inside the system, and they go through decisions like when do you turn a network off, when do you keep it on, etc. What was lacking, I think, at times, and is if you take one thing away, what can I do to best prepare myself, minimize risk to my business, and get back? I can't protect myself. Some of these actors are so sophisticated that there's no product I can buy that builds a wall high enough or a moat deep enough to keep the dedicated attacker out. That's true in government and the private sector. But what I can do is practice and build that muscle memory in my executive team of here are the key steps outside of the technical steps, but who are the key customers and how would I notify them, and what's the best method, and literally who in the company would do it. How would I do that if my network is down and unavailable because I'm suffering a cyber attack? And to your point, Leslie, part of that tabletop should be who's making the determination on materiality, whose job is it to memorialize it, so while others are rightly rushing to put the fire out, you do have some people staying in their lane and making sure that you take those steps that can protect the company later from legal and reputational liability.
So this may sound like a little bit of an off question, but there are, and you mentioned this, I think, at the beginning, there are a lot of competing requirements for notification. So if you are in a regulated industry, banking, for example, we have the FDIC, the OCC, the Federal Reserve Bank. CIRSA put some requirements for notification to CISA, and then within New York, we've got separate state requirements, so state and federal requirements. Is there a potential that if you make a notification under those requirements that you trigger materiality, or are those two things very separate?
It's a great question. And first, boy, are you right? There are a lot of different places, and if you're multinational, even more, where you need to think about reporting that all have slightly different definitions and rules. You know, frankly, it's a system that's great for full employment for lawyers, but otherwise doesn't make a whole lot of sense as a policy matter, including having 50 different states with slightly different reporting regimes if there's personal identifiable information.
Mhm.
And so I think you do need to think carefully about how you phrase the notification for those different obligations, so you don't trigger, if you really haven't determined, or determined, more importantly, have determined it is not material, so you don't confuse the issue. Also think you need to think, carefully about, and this can be part of the tabletop in your incident response plan, what's the cadence? Who do I need to notify in what order? Because that can be confusing when you're in the middle of an incident as well. And your driving impetus may be, it's not the regulators, et cetera. The driving thing that's the CEO is focused on rightly is, if you're B2C, I need to tell my customers what went on, and they got to get it out fast because they're all seeing a disruption, and that's causing incredible harm to the company. I need to get out and explain what's going on. Or whether you're business to business, same calculus. But by doing that, you need to think through your question, Leslie. Okay, well, if I'm going public, I better not have my regulator, depending on my sector, read about it in the newspaper. So who do I need to tell them? What do I need to tell them? And in terms of new rules, for instance, I know Department of Homeland Security, and have worked with them, and we talked with it about it. When they're defining terms under the new statute that trigger the reporting of incidents for the purpose of trying to get a gauge on how bad this problem is throughout the United States so you can track it, the point is not to harm victims, is make sure that the language they use to define an incident isn't the same verbiage that you use for materiality, and so accidentally creates a compliance trap for victims trying to do the right thing.
Okay, so you rightly noted that larger companies probably have less time, but perhaps have less time because they're better situated. What would you advise a smaller company or smaller organization to do? Are there resources that they can draw on? Should they go to a law firm? Should they go to a consulting company to help them work through this? Maybe map out a game plan?
Yes, it's a great point, and you should. And I think what I think about is two areas. So one, get that consultant help on the incident response plan, and if you have the resources, it's your mid-size, if you're a publicly traded company, even if on your smaller side, you do, to invest that time to do the actual run through, to do the tabletop. So, and that's where I see the difference between those who have and those who haven't in terms of being able to respond. And the other thing is get to know your vendors ahead of time, so you're not meeting your law firm, your communications firm, talking about it with your auditor for the first time in the middle of the crisis. And also that to make sure, if you're insured, that you like and work well with those that the insurers have on their approved list. And if you don't, pre-incident, you ask for exceptions to make sure you can select your own counsel. And if they're not willing to do that, then maybe they're the wrong insurer for you. But those are also questions a lot easier to have pre-incident than when you're in the middle of the incident and don't have leverage.
Right. And then boards of directors, what advice would you give a board? How can they best provide challenge and oversight in this kind of a situation? And I'm thinking pre, during, post.
It's the other part of the new SEC rule, which has to do with annual disclosures as well. Specifically calls out boards of directors, although they did not include the controversial original request of requiring someone on the board to be a cyberspace.
Yeah. Mm-hmm.
So unfortunately, Leslie, they don't all have to hire you, although they're good if they do. But I think the SEC remains focused on that area and on disclosing what type of expertise and govern you. governance you have in hand. So a couple of key things I think that every board should do. So one, you need to determine your sector risk. And if you're in a critical infrastructure sector, then exactly as you said, you often have to get briefed to understand your threat environment and should know what the regulator is and what the risk poses to the company, including, when relevant, thinking about whether you have the necessary security clearances to be able to deal with and handle with information, which, depending on your sector, can also often be a real issue. Second, I would, even though it's not required, try to make sure that there's one member of the board who has some cybersecurity expertise or is receiving extra training around cybersecurity, and so is comfortable with asking the type of questions that need to be asked. And it's a good way to show generally that the board has really thoughtfully addressed this risk. Third is to consider having a committee on the board with specific responsibility for managing cyber risk. I've seen that handled, sometimes that's in audit, sometimes now it'll be in a technology or other committee, but have a thoughtful and documented process where you discuss the risk as the full board and make a conscious decision who's managing this risk, and wherever that resides, they should receive regular briefings from the person with the responsibility for cybersecurity, whether that's the Chief Information Security Officer, the CIO, or both, and at least annually should be getting briefed by outside experts on what the threats are. And really, a lot of the responsibility of the board is pre-incident, making sure you're asking the right questions of the company so that they're ready. During an incident, there's not much of a role other than being notified. And in fact, despite this is an interesting and new area, it's one I always remind board members, so we could best defend you later, you need to make sure you play your role as a board member. Unless you have specific reasons not to, you can rely on executive management and should rely, and that's a defense against whatever occurs with the company, unless you get so involved that you effectively become part of the management team, which is why it's more of a notice role during the incident. And then after the incident, making sure you get briefed, ask questions about what occurred, what you've learned from it, and what improvements can be made in the future to reduce risk.
If I could, just a couple of things I'd add to that. Make sure the board is part of a tabletop exercise. They need to be, they need to know what could happen the day of, and I think it's one of the better ways for management to demonstrate how they are working through the potential for an attack. The other thing is, I would say I agree with you on doing the detailed discussion inside of a committee, but I also think that it has to come to the whole of board. The discussion has to come to the whole of board, and it's going to be a higher level discussion, but at the end of the day, if there is an incident, the entire board is going to be held responsible. It's not going to be a committee, and it's not going to be one person. So thank you, John. I really appreciate it. I learned a lot. Thank you.
Great, and thanks for having me,
John.
Hey, Matt.
That was excellent. And really what we needed to hear for those of us that do have to engage on these issues as they come up. And thank you very much, as we're going to transition now to the next session.
Great.